Okay, thank you, everybody. Thank you for waiting around. The committee met for an extended period of time in executive session, and the purpose of that was to hear from our counsel, Jenner and Block, about what we have uncovered so far in terms of the document review, literally thousands and thousands of pages of documents, and what our next steps will be as a committee. We focused in particular about the completion of the document production. There have been, I believe the number is 28 subpoenas issued. We talked about the completion of those document productions, and largely I would say that with all but 3 or 4 individuals, the production appears to be complete, and I say the word appears advisedly because we still have yet to go through them and compare fully what they've given us as to what we've expected. There are 3 entities that we had agreed to, because of the volume they would produce, to do what's called a rolling production. One of those was the governor's office. The other was the governor's re-election campaign, which started late because they had to get an ELEC ruling, and I believe we're still waiting for documents from Mr. Sampson. And we will continue to pursue those, and we've given instructions to our counsel to follow up on those. We additionally spoke about the next steps. Obviously, one of the things we talked about when we started this process was ultimately the need to bring individuals before the committee to obtain oral testimony based on the documents we've reviewed. We believe we're approaching that point in time. We don't have any final conclusion on that because there's still some work that we need to do to make sure that we're doing it in the proper fashion and not doing it any way that would potentially interfere with the U.S. Attorney's investigation. And then finally, we talked about the Gibson-Dunn report. We heard our counsel's assessment of that report, and we've also talked about the need to obtain documents that form the underpinning of that report. Those of you who have read it know that the report refers copiously to interviews with 70 individuals. Those 70 interviews are not footnoted, nor are any summaries, transcripts, or documents related to those interviews made available. We've instructed our counsel to seek them out from either Gibson-Dunn or the governor's office, but we also gave a firm deadline after which we will avail ourselves of our the methods that we have assigned to us by the resolution to compel production. Senator Weinberg?
I think that sums up what took place this afternoon. I don't have much to add to it. Except that we are looking forward to getting what my colleague calls the underpinnings of the so-called Mastro report. And we have a date certain that we hope there will be some compliance. The committee was made aware, full committee has been made aware of what we potentially think the next step should be. So with that, if you have any questions, we'll be happy to answer.
Yes.
Of the governor's documents, his cell phone, his text messages, his emails. Have you been able to get that?
Those are part of what we've already started the process with the Gibson-Dunn firm of requesting all of the material that is referenced in the report that has not yet been produced. The Gibson firm has represented that everything but the interviews has been produced in the document production. You may not be aware, but on the eve of the report being issued and the day of the report, literally we received tens of thousands of pages of documents. We're still in the process of ascertaining exactly what's in that. If we don't have all of that factual underpinning for the report, that obviously will be something that we request. If we do not get compliance with that request, we will take the next step. Josh?
So you say that you're beginning the process of directing counsel to seek these documents. Is that a subpoena that is going over, or is it a more informal request, and the next step when you say compel, does that then become a subpoena?
I mean, ultimately, the ultimate tool the committee has is the subpoena authority, which would compel the production of documents or people. We've instructed, there has been a dialogue back and forth with the Gibson firm about the production of these documents. We want to allow that process to play out and give a fair opportunity for the governor's counsel to cooperate with the committee, but we do have a limit. We do have a deadline after which, you know, the notion of cooperation, as I learned under the Assembly Transportation Committee, is you can be led to believe that cooperation is just around the corner. We want to make sure that there is a firm understanding that we are willing to wait a moderate period of time for cooperation, but after that, we do have at our disposal the ability to compel document production.
This is a follow-up. When is the deadline?
What's the deadline?
The deadline is at the end of this week.
Who do you want to first seek oral testimony from, and when are you thinking that you have oral testimony?
Well, to answer the question in a vague way, is that all of the individuals that have been identified in the documents that you're all familiar with are all logical individuals for the committee to take oral testimony from. And there are literally lots of examples I can give. We're not at a point yet where we have that list finalized, but I think that you can look at the communications that started this, the individuals who are involved in those communications, and the folks that surround them as being potentially legitimate areas of inquiry, individuals that we would want in. David?
Assemblyman, why were you so testy with Amy Handlin, and how much of that had to do with Steve Sweeney's comments yesterday?
Well, it had nothing to do with the Senate President's comments. We're here to continue the investigation. At the end of this, we all want to adopt serious reform legislation, but to do it piecemeal, to do it before all the facts are in, defies the logic of why we're doing this. And I would just read, when the governor vetoed the former reform legislation that was sponsored by Senator Weinberg, one of the points he made as to why it was not appropriate to do that bill at that time, and I'm quoting, "Since the full audit is still continuing, enacting statutory changes prior to the release and review of the final report is premature and may be counterproductive." That logic applied then, it applies now.
I'm just wondering how you're feeling today with what you have now and still no ruling from Judge Jacobs regarding the outstanding subpoenas for Bridget Kelly and Bill Steppe.
As a practicing attorney, I never make it a habit of questioning the timeline of any judge, and so we will be content to wait until Judge Jacobson issues her ruling. We have utmost faith in the arguments that our counsel made. We believe that we're in a strong position, but ultimately it is in the hands of the judge, and we'll await her decision.
But knowing what you have before you now, what your counsel has had the opportunity to look at, given that it's tens of thousands of pages, is there still a significant amount of information missing that only Kelly and Stepien and, of course, Wildstein can fill in the gaps?
If I knew what she knew, then I could answer that question, but I don't, and so that leads us to the position we're in, where we would really like to be able to review those documents. We'd like to be able to continue the investigation to the point where we can have individuals come in and offer oral testimony. There's a lot of questions that are still outstanding that cannot be fully answered even by any fulsome document review. I mean, even if we had Bridget Kelly's documents, we still don't know the answer potentially to why. Why was that email sent at 7:30 in the morning?
Senator, two questions here. One, did you issue any subpoenas today? And two, insofar as former Chairman Sampson is concerned, has he or Wilkin Sampson, the law firm, actually begun to cooperate by turning over any material, or indicated that they will turn over material?
No, we didn't issue any subpoenas today. That's the answer to your first question. And I don't believe, and you could correct me if I'm wrong, that Mr. Sampson's documents have come to us yet in any form whatsoever.
Just one slight, not to contradict my co-chair.
Feel free.
There is, we have gotten a very small production of material
From the Port Authority.
from Mr. Sampson's production. We've been told that more will follow. We've asked our counsel, as I mentioned early, there are a couple of cases where we've been told that people will still be complying on a rolling basis, and we've said, okay, we've been rolling now for 2 months. It's time to bring this rolling to a conclusion. When can we get them? And we've asked our attorney to do that.
You mentioned
Can I ask, on the subpoenas, the way I understand what you just said is that if you don't get the material you want by the end of this week, you will issue the subpoenas, that's correct, right?
That's correct.
Okay, and how many subpoenas are we talking about?
This would be to either the Gibson firm or to the governor's office. We're awaiting advice from counsel as to which of the entities would be the appropriate one to issue a subpoena to, if we get there, we're not there yet, to get those documents, the underpinnings of the Gibson report.
They would be to the office and to the law firm, not the individuals?
Well, that's one of the things we're waiting for advice from counsel on. They've been in discussions with the law firm. I'd like to wait to have them make that final decision. Charlie?
You mentioned that before you bring more witnesses in for oral testimony, that you want to make sure that you do it in a way that won't interfere with the U.S. Attorney's investigation. How much consultation have you had directly with the U.S. Attorney's Office? Are they giving you guidelines or instructions on what to not ask and what to avoid?
Well, I don't want to get into the specifics of our attorney's conversation with the U.S. Attorney's Office, but what I can say is that there has been communication. Our counsel has advised us on how to proceed. We're very comfortable with how we're proceeding, that it is not in any way interfering with the U.S. Attorney's investigation, and we'll continue to seek our counsel's guidance so that we continue to abide by that principle.
Just
Can I follow up on that?
follow on that. I'm sorry, but the
She's next.
okay, there is this perception though that as this thing plods forward, that there's going to be a crisscrossing, there's going to be a collision, and that maybe your work here could interfere or intrude or undermine their investigation.
That's an excellent point, but I think the one thing that always has to be underscored is the end product of what we seek to do is different than the end product of what the U.S. Attorney's Office seeks to do. They are looking potentially at some type of legal action, potentially on the violation of either federal or state laws. We are looking at understanding how this could happen so that we could intelligently put together a reform package that fixes the Port Authority, that fixes the governor's office. And so there is a jurisdictional boundary issue, if you will, in terms of when we act and when they act. But I don't think that there's ever a point in time where it's impossible for us to move forward with what we need to do ultimately and for them to move forward with what they need to do ultimately, because there's two different end products.
Is one of your concerns, though, from what I understand, that New Jersey state law says that if they come here to testify, they get immunity even from federal prosecution. So isn't that where you risk interfering with the U.S. Attorney's investigation? That you shut down the prospect of criminal prosecution?
Right, and so the best way I can answer that is that our counsel has had conversations and we're comfortable in following his advice that we won't be interfering with the federal investigation on how we proceed. That's the best way that I can describe that.
We saw some tension on the panel this afternoon, as referenced earlier. How are relations among the Republicans and the Democrats? What is the level of cooperation at this point?
Well, I'm going to let my co-chair address that,
Yeah,
but I'd also like to address that.
usually much better once we go back there than they are out here, which says a little bit about what what performances might be required. But in fact, there are very little problems raised when we go into executive session, and there seems to be a general unanimity of opinion to move forward, to respect the advice of our counsel. And I heard no objections, and as I said, I think we get along much better when we're in executive session.
I was just going to echo those comments, is that when we're not out here in public and there are no microphones on, it seems like we get down to business and there is a consensus that the Port Authority needs to be reformed. There's a consensus that there's a need for legislation. There's a consensus that on some of the issues that we're talking about here in terms of getting documents from the Gibson-Dunn report and those type of things, it seems like when we're out in public that changes.
Chairman, to that point, this has become in many ways a national fascination, whether it be on nightly shows or on evening news. Does that, in and of itself, the fact that so many people across the country seem to be interested in this, does that impact this at all? Does it put pressure on you guys to come up with some sort of resolution of this sooner or anything along those lines?
I don't, and I'll let Loretta answer this, but, go ahead. No, you don't want to?
Yeah,
I thought you were going to say something.
No, I was going to say something. I will use a little interchange I had with my daughter, who lives in California, about some reference to a New Yorker article. And she said to me, "Can I have your autograph after you finish folding the laundry?" So, no, it doesn't, I don't believe it brings any pressure to bear on any of us. There is obviously a fascination, probably because there had been this national fascination with the governor. So I think it derives out of that, but I don't feel any pressure to move slower or more quickly. I feel pressure that we want to get at the truth. What happened and what can we in the legislature do to make sure that it doesn't happen again?
And let me just follow up on that, is that we're going to get one opportunity to do this and do it right. And so speed is not something that's high on our list. Doing it right is. And so somebody has commented that we've been at this for a couple of months. A lot of it is not at our choosing. We've got a court case we're waiting for a decision on. But the opportunity to do this examination, the opportunity to propose reform to the Port Authority at a point in time when everybody sees exactly what went wrong at the Port Authority, and hopefully we have a report that explains what went wrong, is a unique opportunity to put together legislation. It won't come our way again, and so we have to do it right. And so if it takes a longer time, that's just how it's going to have to happen, yes.
Chairman, considering the difficulty in getting the documents that you're seeking and getting witnesses to be very forthcoming when they do show up here for oral testimony, how confident are you that you'll get those eventual answers as to how this would happen and who the culprit was?
Well, that's a great question. We've had 5 people testify on this topic. All of the testimony happened under the Assembly Transportation Committee. We've had 4 people testify under oath who came in and answered questions and participated in the process, and we had 1 person who took the fifth, David Wildstein. In this situation, now under the Joint Committee format, we've issued 28 subpoenas. All but 2 have provided documents. And so while you articulately state the question about these impediments we've run into, we've gotten far more cooperation. We've had far more opportunity to ask questions, and we'll continue. As we've said, there are other people that we believe we are now approaching a time where we can actually bring folks in for oral testimony. That will help provide answers to the questions we have. To answer your ultimate question, will we know all the things we want to know? I won't know until I ask all the questions. And so stay tuned. Angie.
What kind of cooperation have you gotten so far from Gibson Dunn, and have you gotten any indication as to whether they're willing to turn over the documents that you seek, either voluntarily or that they'll comply with the subpoena?
Well, to be fair, they've indicated a desire to work with our counsel in turning over the documents. But that indication has stopped short of saying, and yes, here they are, they'll be delivered tomorrow. And so we're at a point in time where they've indicated an interest in cooperating, but have not actually said when or how much. That's why we've instructed our counsel to set a definitive by this date deadline, after which we will avail ourselves of our other abilities.
Just to follow up, just to be clear, the subpoenas will be dropped Monday if they don't comply on Friday, or will they be dropped Friday, or how does that work?
They probably just, to give everybody the fair due, they probably, if we don't get cooperation, they probably would come some point after Friday.
So when you said there were 2, I'm sorry, when you said there were 2 that did not comply, those are the 2, the law firm?
No, we're mixing things. Okay. We're not talking about the 2 being documents. We're saying there are 2 people who have refused to produce documents citing their Fifth Amendment right. That's a separate issue than what I'm talking about now. We're talking about the Gibson firm producing the material that forms the basis of the report.
Just talking about the timeline of this and cooperation, is Friday enough time?
This discussion's been going on for some time. Well, the report and the documents were
About
issued
2.5 weeks.
11 days ago, I think, or 12 days ago. And clearly, they've had that material long before the Friday that that report was issued. So it's not like other document productions where somebody might have to search for something. This is stuff they've used to prepare the report.
You think you'll get from your counsel that the decisions that you'll subpoena and file them, you're confident about that, whether it be the government secretary's office or individual?
Oh, yeah. We're working through that process now, and so we'll obviously when we issue them, we'll have very clear understanding of where the proper place to issue those. But I really want to emphasize, because the focus of the questions have been about when it will issue and who it will issue to. Our hope is that we can secure this material through cooperation. There has been an initial discussion. It hasn't resulted yet in a specific, we will do this by this date. We're hoping to get that. And so let's let that play out and see what happens.
Chairman.
David.
You said that your counsel gave you all an assessment of the so-called master report. Can you share what that assessment?
Not an assessment.
Well, we talked about what's in it, what's not in it. We talked about, for instance, the fact that there are 70 individuals referenced throughout the report that have been interviewed, but there's nothing in the report in terms of an appendix, exhibits that would substantiate those interviews. So we talked about that, David.
So, but he didn't, or she didn't, I don't know who it was, didn't give you an assessment of the quality or lack?
I already made my own assessment about that, so I didn't need the council to do it.
What is that?
Just a
assessment?
couple more questions, please. Chair.
quick question.
Chris, I'm sorry. Go ahead, John.
A quick question. The 70, were the 70 interviews taped? Were they transcribed by a reporter, or what form are the documents that you're seeking?
Well, we're hoping to find that out. My understanding, and this is just my understanding, I don't have any independent corroboration, is that there were no transcripts made of these interviews.
But are there tapes?
My understanding is that there are not, but again, we have asked for all of the relevant material. We don't have a response yet, and so we're waiting to see. But I see the questions on your tongues, absolutely.
Chairman,
Christine.
I just want to make it crystal clear. So you don't think there were any transcripts or audio tape on this, but again, just to be crystal clear on this, you do not have the names of the 70 people who were not interviewed.
That is accurate.
And do you have text messages, emails, and cell phone records reviewed by the government?
I don't believe we have those, but I do want to, there was a lot of material produced. I want to make sure I confirm that with our counsel, but I don't believe we have that material, or if we do, we have a very minimal amount.
Assemblyman, if you don't think there were tapes or transcripts, what are you, to the best of your knowledge, seeking?
I am operating under the assumption that in order to prepare a report that in many, and I know many of you have read it, that said the sum and substance of what so-and-so said is thus, that they record it in some fashion, a memo, notes, something that would have preserved what was said. I may be surprised there may be a transcript. I may be surprised there may be a tape. My understanding as I speak here now that it is perhaps just interview memos. Whatever it is, the committee ought to see it and make its own evaluation to compare the summary that was provided in the report against the notes that were taken at the time of the interview.
Have you spoken with the Senate President since yesterday, and what were your thoughts on his remarks that he seemed to cast doubt on continuing the investigation in case you lose the court case? And
Yeah, but
walk back?
I think that, he spoke during an editorial board, and subsequent to that, he clarified his remarks. I will let Senator Weinberg speak to that, but I think we're both very comfortable that he is supportive of what we're doing and having the committee continue its work to conclusion. Senator?
I absolutely agree. I think there was a miscommunication, perhaps an inartful way of answering a couple of questions, but he has very, very clearly stated where he stands now, and I think most of you had a copy of that press release.
One last question.
Senator Weinberg, what did you think of the way the governor's story on when he first learned of the dedicated lanes, quote unquote, has changed between the December 2nd news conference and his most recent one?
Well, since there are no dedicated lanes, and there were no dedicated lanes on September 9th, and there were no dedicated lanes on December 2nd, and there were no dedicated lanes on January 8th. So everybody can draw their own conclusions.
Does it sound like, though, he was supporting a cover-up there, a false story of the
Well,
study?
I do not want to characterize it that way. As I said, there are no dedicated lanes. My former colleague, Bill Baroni, came before the Assembly Transportation Committee, not subpoenaed, not under oath, claiming this whole thing was done because of dedicated lanes. I remember the governor even using an expression that he was a little sauced about finding out that Fort Lee had their own private lanes to get across the George Washington Bridge. The fact is, there are no dedicated lanes. There were never dedicated lanes. And so I'm sure the public and all of you can draw whatever conclusions you wish from that.
Shirley, this is the final one.
In the early stages of this investigation, the Republican criticism was that this was a biased political witch hunt, and it was seen by many as an attempt to kind of discredit the work of this panel. Can you, is the recommendation by Assemblywoman Hanlon today, in part, do you see that as part of a similar theme, as a part of a trend by the Republicans to find some way to derail the work of this committee, and i.e., if there's reforms enacted now that might take the air out of the long-term purpose of this work of this committee?
I'm concerned about a philosophy that may exist that says, we know as much as we're going to know, let's just go to the bill, create legislation, and move on. We're not finished. We don't even have Judge Jacobson's ruling. And even if that ruling were to be adverse to the committee, there is still a lot of material that we need to review. There are people we need to bring in for oral testimony. And only then can we legitimately say we've exhausted the factual information to help us make a decision on how to reform the Port Authority. But as I said earlier, this is a unique opportunity for the state to give us the ability to reform this Port Authority because we've seen firsthand how it can be misused. We ought to use that opportunity to its full extent to enact legislation, and anything short of that, I would be worried we're missing an opportunity.
Any thought given to a cap on how much you can spend to get to the truth on this?
What's the price of truth? Thank you all very much.
Thank you. That happened.